Now let's have a little think about something more in depth with regards to will planning. Many people have heard of property protection trusts, or PPTs. Now, just what is a PPT? A PPT is a trust within the will. Now, what do I mean by a trust? Trusts are a myth. Trusts cause distress, concern, that they're for the super rich, that they're very complicated. Now, a trust is quite simply an arrangement between three sets of individuals. The person who establishes the trust, which is sometimes called the settlor, or in the case of a will, the testator. The trustees, who manage the trust on behalf of the person who sets the trust up, and then the beneficiaries. So in the most simple form, a trust is a very, very basic arrangement. Yes, of course, they can be used for people to make huge tax savings, but this isn't something with which we get involved. Now, a trust within a will is there to provide protection. When we structure wills, we can have what we call outright or absolute gifts. And that is when the person who makes the will passes away, the inheritance, the gift, the legacy, whatever it is they are leaving, drops straight into the lap of the recipient. Now, of course, this may not be beneficial to the recipient. Just imagine if they were going through a divorce, through bankruptcy, they were living abroad. Something unfavourable which would mean that inheriting at that particular moment could not be very beneficial for them. So a trust is there to provide a layer of protection around that inheritance. It allows the trustees to negotiate with the beneficiaries to decide when is the best moment for them to inherit, when the divorce has passed, when the bankruptcy is over. If they're living abroad, when they've had time to take legal, tax and financial advice both in the UK and in the country in which they live to ensure that their inheritance isn't stung under local tax laws. Now, specifically, a property protection trust covers, as it may sound, the property, usually the family home. Now, in a common scenario, the husband and the wife own a property jointly, whether it's as beneficial joint tenants or tenants in common. Now, if the husband was to pass away and to leave the house outright to his spouse, imagine two very, very common potential scenarios. As a younger couple, imagine if that spouse got remarried. Imagine if that spouse got remarried to someone and had children of her own with the future spouse. When that husband passed away, he left his share of the house to his wife with the full intention that perhaps it would go to his children, to his brothers and sisters, or even their children. But the remarriage has caused what we term sideways disinheritance. His share of the property has gone to his wife, and this could be diluted down her new partner's bloodline. Second situation for an older couple. Imagine the husband passes away and leaves his house to his spouse. Imagine she ends up in residential care. Residential care on average could be £50,000 to £60,000 a year, and it wouldn't be long before that family home is means assessed. And as we shall discuss later, whilst the family home is not necessarily going to be sold, a charge could be put on the property sold, and the proceeds used to discharge that liability after death. Imagine if the husband had set up a property protection trust in his will, leaving his share of the house in trust for the benefit of his spouse. She could live there, she could downsize, she could upsize, she could do whatever she needed to do. But crucially, the whole house doesn't become her asset. If she then ends up in a care home later on in life, the local authority are only able to assess the value of half the property, meaning that the husband's share, when he passed away, is locked away and protected for the benefit of his children or his chosen beneficiaries. And in the case of the remarriage, imagine if the husband, rather than leaving the property to his wife, had left it for the benefit of a property protection trust. If she remarried and gave her share of the property to her new husband, to their children, to her sisters, to whoever she gave it to, the share of the property that was held in trust by the husband when he passed away is guaranteed to go to his chosen beneficiaries. So with a little bit of thought, a little bit of structural change, it is perfectly possible for the first spouse to die to protect their half of the house from any unforeseen third-party attack, whether it be the local authority, future taxes, foreign tax systems, divorce, bankruptcy, or even long-term care. So we have what I term the triangle of estate planning. We have wills, we have lasting powers of attorney, and we have lifetime family asset protection trusts. Wills appoint the persons that you choose to look after both your children and your assets to ensure that they pass to your chosen beneficiaries as quickly and as smoothly as possible when you pass away. We have lasting powers of attorney, which are documents that appoint the people that you choose to make decisions about your property and financial affairs and your health and your welfare when you're no longer mentally able to do so. And then we have lifetime family asset protection trusts, which protect your assets against third-party attack from divorce, from bankruptcy, from foreign taxes, and potentially from future care fees. Now, I wish I was able to cover the whole of the United Kingdom, but unfortunately, I'm not. So I work with a network of trusted associates, strategic partners, who will be able to provide you with bespoke advice about some, all, or other aspects of estate planning that we haven't necessarily covered today. So give them a ring. Find out what they can do to help you. Now, you may choose to put all of these things in place or none of them, but at least have the conversation to understand the consequences of the decisions that you're making. You can go in fully informed to make sure that your family's future is as protected as it can be.